Good morning, everybody. My name is Alex Sharastani. I'm the founder of the Journal of Law and Technology at Texas, and welcome to our first annual Law and Technology Symposium. Today we have a great lineup. We're going to be talking about cyborg rights, self-driving cars, election hacking, and we're going to be talking a little bit about police body camera surveillance. And I'm proud to introduce Rich McKinnon, the moderator of our first panel.
Hi, good morning, everybody. I'm Rich McKinnon, and I'm the founder of BorgFest, which is a cyborg festival and human augmentation expo here in Austin, Texas. And currently it exists as a series of mini events. We consider this morning one of our mini events, this particular panel. So before we can talk about, let me introduce, or have them introduce themselves, the other panelists. So we'll start with Matt Tate.
Sure. So my name's Professor Matt Tate. I teach cybersecurity in the law school. I'm an adjunct professor. I'm also the CEO of a cybersecurity firm called Capital Alpha Security. Prior to that, I used to work with Google in Google Project Zero. I used to work with Microsoft doing security assessments of Windows. Before that, I used to work in consulting as well, and also at GCHQ, which is the UK equivalent of the National Security Agency.
My name is Matt Powers. I am currently an attorney at the law firm here in Austin of Graves, Doherty, Heron, and Moody. My law practice is a broad commercial practice, including intellectual property issues. Before joining the firm I'm at now, I spent 2 years clerking for a federal judge here in Austin, Sam Sparks. And before that, I went to school here at the University of Texas. It seems like a long, long time ago now, but went here for both undergrad and law school, and excited to talk to you folks this morning about the Third Party Doctrine and cyborgs.
Great, thanks, guys. So before we can get to the very meaty topic of cyborg rights and the Third Party Doctrine, I'm going to assume that most of you aren't really sure of what a cyborg is, at least the way we're going to discuss it. Why cyborgs need rights that are different from any other kinds of rights. And then once we have a handle on that, we can figure out how it intersects with the third-party doctrine and why it's particularly germane not only to cyborgs but all of us. So let's deal with what is a cyborg, at least in the way that I'm sort of promulgating it. So think of cyborg as an identity more than a technology. So many of us are tempted to think of cyborgs as like the $6 million man, the bionic man, Terminator, that type of thing, or RoboCop. And while these are all, views of what a cyborg could be, a cyborg doesn't necessarily need to be a robot man type of thing. A cyborg is an identity. And there are 4 major identity categories that cyborgs fall into, and these are not mutually exclusive. The first category is human augmentation. Now keep in mind that cyborgs don't need to be human. They can be animals and insects as well. In fact, the word cyborg is an amalgam of 2 other words, cybernetic organism, right? So it could be an organism augmentation. But to keep things simple for today, we'll just say human augmentation. And human augmentation contains the subcategories of prosthetics, orthotics, transplants, implants. These are interventions that help you replace a lost capability, typically augmentation. The second category would be performance enhancement. And performance enhancement would be another type of intervention that makes you able to do something beyond what's considered normal. So my favorite example of this is Oscar Pistorius. Oscar Pistorius, by most accounts, began his celebrity as what we would say is a disabled man. He had prosthetic legs, and then they were modified to help him run again, and not only run again, but faster than most of us. So these prosthetics were enhancing. They enhanced his performance beyond what we would consider normal for anybody. But take note, though, that these prosthetics were not electronic. They weren't mechanical. They were materials engineering. There are no moving parts at all. So performance enhancement doesn't need to be something like the bionic man, so to speak, for you to have an enhancement. So in that regard, I consider Lance Armstrong, Barry Bonds, and A-Rod to be cyborgs because they are performance enhanced, and I call them pharmaborgs, pharmaceutically enhanced cyborgs. Okay, the next category would be body modification. And again, think of it, this is an identity category, all right? So body modification would be any type of modification for stylistic, personal, professional, religious, aesthetic, artistic, political reasons, all right? And while not all of these modifications may make you a cyborg, some of these modifications may lead you to be treated like a cyborg, right? So again, it's an identity issue. We can get to kind of what that means more later, but that's a provocative statement. And then finally, the fourth category is wearable tech. And now this is kind of the realm of the cyborg anthropologists. Cyborg anthropologists will say that cyborgs have been around us as humans from the beginning of humans. From the first time we picked up an object that we used as a tool, and it became a permanent tool in our lifestyles because it made life better. The first time we put on shoes so that we could walk for a very long distance was an augmentation and an enhancement that we now know it's rare to walk long distances without shoes. And indeed, when you think about humans and clothing and how closely we are associated with this tool that we wear, it is more common to see humans with clothing than without. So anthropologically speaking, the things that we wear, the things that we hold, can become so a part of our identities and our culture that they become a part of us. And we've heard the argument with phones, like we can't drop them, and how long will it be before they're actually added to us in the other categories of augmentation, enhancement, and modification. All right, so those are the four categories. Now you understand kind of what we're talking about a cyborg. How do people become cyborgs these days? A lot of people become cyborgs through medical problems. Some people become cyborgs through traffic accidents or war. Some people are born as cyborgs. So they enter as patients and consumers and veterans. San Antonio, for example, there are more amputees per capita in San Antonio than any other American city. And it's because of the way the Army filters their wounded warriors from Fort Hood over to the Brooks Army Medical Center. And so there's a huge service provider ecosystem with them. So there are a lot of cyborgs in San Antonio, okay? And then on the civilian side, we have cyborgs through diabetes and amputations, okay? So think of it that way. You will become a cyborg through this kind of medical intervention, but you think you'll start off as a patient. So now let's get to the next thing. What are cyborg rights? We have our own set of civil liberties that we all understand. That's extended to every United States citizen and copied to some extent, more or less, by other states in an aspirational sort of way. All right. So the problem, though, is what happens when these civil liberties don't necessarily extend naturally to what a cyborg is. And let me give you an example of that. So many years ago, yes?
I'm sorry, I have a question.
Yeah.
I understand the term. How about if someone has a kidney transplant or heart transplant? Are those cyborgs also?
Yeah, under the first category of transplants.
I just wanted to make sure.
Yes, that's right. If you recall, many years ago, when electronic mail and computers and hard drives and data and all that stuff was just getting started, the courts and the cops and the law schools were not at all prepared to understand what this stuff was and how it was covered by Fourth Amendment and First Amendment. All right? So we needed an organization like the Electronic Frontier Foundation to basically extend our civil liberties into the next frontier. All right. Is there anybody here that doesn't know about the Electronic Frontier Foundation and that example that I just gave? Awesome. Now I can extend the metaphor. So the new metaphor is what happens when the new electronic frontier moves within our bodies. Okay? Prior to the establishment of this new frontier, we always thought of our bodies as wholly owned by ourselves. And that was just sort of the basis of all our liberties moving forward. But increasingly, these interventions are going to add property that's owned by third parties, either in hardware or software, and as well as the data it produces. And over time, you can envision a human body that becomes a matrix of third-party ownerships and properties and intellectual properties owned by other parties with competing legal agendas, right? And that most of us haven't really read or understood any of the rights and warranties associated with these things. All right, so now you're kind of getting to understand why cyborgs need rights. And last March during South by, I wrote the Cyborg Bill of Rights, and you can take a look for that. You can Google it, and you can see how I'm orienting the discussion to the kinds of rights we need. That brings us to today. All right, the Third Party Doctrine. Is there anybody in the room that doesn't really know what the Third Party Doctrine is before we dive into cyborg rights and Third Party Doctrine? Okay. Matt Powers, you're the Third Party Doctrine guy. Let's give a brief summary of that, and then we'll return back to the narrative.
Sure.
Yeah.
So, yeah, I think it's helpful to have some framing. Essentially, over the last century or so, the Supreme Court has been grappling at the early part with a fairly primitive stage of technology and now much more advanced state of technology with how does the Fourth Amendment react to claims to be able to search or seize. The Fourth Amendment language is persons, effects, papers, homes. And so what the court has done, if you go back to the 20s, the Prohibition era case of Olmsted, the initial attempt to try to grapple with this issue, the court looked at wiretapping for the first time and concluded that wiretapping was okay, there was no seizure there. So long as there was no physical intrusion into space, that there was a permissible attempt to wiretap without going through the process of getting a warrant. And that law survived for some time, really until the 60s, when the Supreme Court in the Katz decision finally decided that there is a reasonable expectation of privacy in private conversations. That was a case that involved an effort to listen in on a conversation involving, that was taking place in a phone booth, and the question that the court ultimately wrestled with is, what are we going to do about that situation, and concluded that if there was that reasonable expectation of privacy, they'd close the door. There was more and more an understanding in the populace that people want and expect privacy in those kinds of contexts, that the court finally did start to insist on warrants in situations like that and looked at that as a Fourth Amendment violation when one wasn't obtained on probable cause in advance of the listening. And from there, in that backdrop, you start to see what Rich just referred to, the Third Party Doctrine became a question that the court began to deal with in the 70s. And it turned on that framing, reasonable expectation of privacy. And the court initially, when it looked at these questions in cases like when a person turns over information, records to a financial institution, and they asked, is there a reasonable expectation of privacy in that transaction? And in early cases in the 70s, they said no. And they said no because in a situation where a person is handed over documents or information voluntarily to a third party, that's a situation where they shouldn't assume that that's going to be treated privately as against anyone, much less the government. And they came to the same conclusion in a case also in the 1970s involving phone records, essentially. It's Smith versus Maryland is kind of what's, I think, regarded as one of the most influential third-party doctrine cases. And that case involved a situation in which a woman had been robbed and began receiving phone calls from her robber threatening her after the fact. And the police began to investigate. They got a lead on first the identity of his car, and then eventually traced it back to his residence. And they went and were able to set up what's called a pen register on his phone number. and were able to see the outgoing calls he was making. And they did that without obtaining a warrant in advance. And the court analogized to some of the decisions they had already reached and said, this is a situation where when he is making these phone calls, he is voluntarily and freely turning over the digits that he's dialing to the phone company, a third party. And in that situation, we're going to conclude that he has no reasonable expectation of privacy. And so the third party doctrine there was the basis in a mixed decision, split decision, but one that the majority ultimately held. No Fourth Amendment violation, no warrant needed in order to set up that pen register. And the conclusion in that instance was that that was okay. And Smith v. Maryland is still the law today. That hasn't changed, though in more recent years we've seen signs that it may be narrowed, it could be overruled, and I guess one of the questions that panels like these ought to be thinking about are kind of what do we think that the answer ought to be in cases like that? Do people have a reasonable expectation of privacy? Because with the further evolution of technology since the 1970s, more and more we're seeing situations where modern life simply can't happen without the divulging of information to third parties, like your phone company, your cell data provider, all sorts of things. And so we're seeing more and more things pop up, situations over the last few years. We can talk about some further examples. But in a nutshell, the third party doctrine is simply this doctrine that has concluded when information is turned over voluntarily to a third party, that's a way out of the warrant requirement that ordinarily you'd see in the Fourth Amendment.
Thanks for that great summary. I'm gonna sort of wrap it up, and then we'll get to you, Matt. Okay. So again, now, if the modern cyborg is voluntarily turning over data to Facebook, Google, Alexa, Siri, etc., and then that information is easily attainable by way of the third-party doctrine, what happens to the Fourth Amendment for cyborgs, especially as more of us become cyborgs rather involuntarily? Some of these, I could argue this is the anthropological cyborg. So you can say, Rich, you don't need to give your information over. Okay, I'll say that's fine, but what about all the various medical devices that are installed in me, right? And do I also have the same option of choosing not to hand over that information? And the answer is probably not, right? So that information is going over to a service provider who probably then also knows my life signs and my location, and through data analysis can make a lot of assumptions about what I'm doing and where I'm doing it. Think about all of these different devices are synthetic anatomies or alternative anatomies or cyborg anatomies. I'm using different metaphors to help you understand what a medical device or implant can be thought of in the future. Okay? When you have all of these things communicating with third parties, it's not hard to see how the third party doctrine can come into play. So now, Matt, it's time for you to hit some of these questions. Do you want me to just start with the top, or is there one you were drawn to?
Whichever one you prefer.
Okay, so Samuel Higginbottom came up with some really great questions. I wonder if you all saw some of them before you got here, and that's why you're here. So I thought it'd be a great idea to just hit some of these questions, and if any others come organically from the audience, we'll get those too. So the first question is, do you think that courts will make distinctions between treatment of data collected by different kinds of cyborg technology, such as medical devices, smart prosthetics, and personal assistants?
So I think we're already starting to get to the point where the court is taking a slightly different approach. Certainly when we look at lots of the older court cases, people weren't sharing very much information, and the information that they were sharing, they were sort of doing quite consciously. It was quite discrete information. It was things like, I'm going to make a payment from, my card to this retailer. There wasn't sort of a massively revealing amount of information there. So I think the court took the position that, if you wanted it to be secret, there's ways of you making these transactions that are secret. You have affirmatively chosen not to. If it was so important for it to be secret, don't share it, right? And that's basically how this third-party doctrine has grown up. Much more recently, we've seen the court really have to take different positions, because the amount of data that we are producing and the amount of data that we're producing involuntarily, and the quality of it and the quantity of it, is now so large that we're starting to see people with access to this data can make quite significant inferences about private events in your life. And we see that at the moment. There's a Supreme Court case currently going through Carpenter, where the Supreme Court is going to have to make a decision based on cell site location information. And cell site location information is, most people in this room, I'm sure, have a smartphone. As you wander around the city, your smartphone has to connect to all of the other smartphones in the world in order to make phone calls, in order to be able to receive phone calls, in order to be able to access the internet. As you wander around, your phone is having to connect to cell towers so that it's able to connect to the cellular network. The fact that you're doing that means that the cell towers know where you are, right? This is information that you've given out, right? So far as the law is concerned, this is third-party information. You've given this information freely to your cell company. And this means that if the FBI really wants access to that information, they can subpoena it from the cell company, right? But the problem is that this is not just where you were at, 3 o'clock on Tuesday. This is where you were at 3 o'clock and 3:01 and 3:02 and 3:03 all the time that you have your smartphone on your person, which for most people is all the time you are outside of your house, right? So really what we've started to see is I think it's quite easy to, when we talk in terms of cyborg rights, people think, cyborgs, that's far off in the future. This is something that doesn't affect me. And you don't really think, well, one day I might have a heart attack, I'll go to a hospital, I'll get a pacemaker, right? And I'm not going to sign an end-user license agreement when I'm, unconscious
Mm-hmm.
in a hospital. And, most of us don't think of, a smartphone as being this sort of externalizing of our consciousness, but in many respects it is, right? Lots of people have this sort of existential dread when your battery gets to 3%, right? And the reason for that is because the way that you think, the way that you interact with the world is actually really quite significantly tied to your device. And the way that the law is structured is that you have a lot of rights, right, through the Bill of Rights. Your phone has no rights, right? Your phone is a device. And so when we think in terms of cyborg rights, I think what we have to be thinking is, where does the person end, the person with lots of rights end, and where does the device that has no rights begin? And actually, is that a sensible way of thinking about the third-party doctrine going forward?
Good. That's great. Yeah, go ahead.
Can I ask you to extend that a little further? Do you think there's a meaningful distinction between data collected on devices that you opted into, like your cell phone, and some like a mass data gathering tool such as automated license plate readers?
So one of the big controversies of the Smith versus Maryland cases, that I'm sure you're aware, is that in the Smith versus Maryland case, they decided that you didn't have privacy in the phone digits that you dialed, and this meant that the FBI could get this without a warrant. And in 2013, it became public via Edward Snowden that the National Security Agency had taken the position that because you had no privacy in the numbers that were dialed in this one case where there's one person who they were pretty sure was harassing this woman, that he didn't have Fourth Amendment rights in this data that the phone company had. The National Security Agency took the position that, well, that means that nobody has Fourth Amendment rights in all of this data. So the current system is that the scale doesn't make any difference, right? If you have Fourth Amendment rights, then one person, or if you have Fourth Amendment rights in that particular piece of data, then one person is sufficient for you to need a warrant. But if you don't, then actually there is no number of people before you decide, well, actually, I need a warrant. You just don't. So I think To answer your question, I don't think the scale changes the law. It doesn't change the legal analysis.
And if I might add, I think one of the things that technology is making clearer is the need to recognize that for most people, privacy is contextual, that people have an understanding that when they drive their car or walk around out in public, that that's something that is going to be known to the people who are standing nearby and seeing them. But that fewer people would say that that also means that it's okay for someone to go and get a record of everywhere I've been when I've moved around in a public place. And it's the same thing with people's online activities. You know, most social media platforms allow people to decide this is okay to share with people, person X, Y, and Z, but not A, B, and C. And I think that a doctrine like the Third Party Doctrine is a relatively blunt instrument because it seems to suggest that those line drawing problems aren't available. And we may see the courts eventually start to take a different look. The decisions that we've already seen come down in recent years have suggested that there's an opportunity for more nuance. The fact that in the cell phone case that was decided by the Roberts Court said that you can't get into that phone without a warrant suggests that an opportunity was there to invoke the Third Party Doctrine, but it wasn't invoked, and it suggests that maybe the court will ultimately take a different path than the one they've been on.
And you've actually answered the second question, which is, do you anticipate the courts kind of shifting from their deferential attitude? And it's also because I'm banking on that is the reason why I wrote the Cyborg Bill of Rights, and I'm putting out a Cyborg Pride Festival to help the public better understand their cyborg selves and cyborg issues. Because if the public doesn't really care, well, then the courts won't either. Is my view. There has to be some pushback for them to respond. So let's get to the next question, which is, what role do you see for manufacturers of cyborg technology in protecting their customers' rights? And on the flip side of that is, do they protect their customers' rights at all anyway? You want to try and take that one?
Yes, that's a really interesting question, and when we're talking about the Third Party Doctrine, we're really talking about privacy, but I think that this even goes wider. Mm-hmm. You know, we've certainly seen with things like pacemakers, there's been cybersecurity vulnerabilities in pacemakers. And the problem is that in the event that there's a vulnerability that means that someone quite close to you can send a command to your pacemaker to say, you know, put X many volts through your heart, right, you're going to die. And so obviously we don't want this to happen. We want, manufacturers of these medical implants to be creating them so that they're secure. We also want them to be creating it so that if it's emitting data, that data is private. There's very significant difficulties relating to, in the event that a vulnerability is found in your pacemaker, do you want to undergo surgery in order to get a new pacemaker put in? Because every time you...
Or a refurbished one, which is so common with other...
Right, and bearing in mind that every time you go under the knife, there's a significant chance you're going to die on the table as well. Yeah. So is there a much higher burden on making sure that the devices are safe before you even go down that path in the first place? But I do think it's a very interesting question as to do the liability, for these manufacturers, how does that change? I mean, there's already some differences. So we have things like HIPAA when it comes to things like medical information has to be protected slightly differently. We already have, I think the FTC is now starting to investigate cybersecurity vulnerabilities in pacemakers in particular. But I do think that this is something that we're going to have to start looking at. I'm not sure it's going to necessarily be solved by the courts. It might be solved by Congress. It might be solved by administrative agencies. But I do think this is something that people are increasingly looking at, and it is something that's quite worrying.
So as you all can see, cyborg rights, while I initially framed them as civil liberties or rights of citizens, cyborg rights have to comprehend also your patient's rights and your consumer rights, because these are the other ways that you get pulled in. But as Matt Powers was talking about, let's say the phone company, they both were talking about the phone company. How warm and fuzzy do you feel as a customer of the phone company and the way that they provide customer service of you. And now you're realizing that they're also the custodian of your rights in a very significant way. So are these really the guys that we want to depend on protecting our rights? So let's go on to the next question. And
I have a question now.
yeah.
That's like, the third party is not required to release the information. Like, Apple refused to release the code that unlocked phones. And then they were finally, someone else was able to hack in and solve that problem. So large corporations are sometimes not releasing the information to police, even with court orders.
And thank goodness, but they don't have to, but some of them also could. And why don't you go ahead and respond to that?
Sure, yeah, and I was just going to throw in that I think that there is a widespread expectation, not universally shared, but many have an expectation that a company like Google or Apple or any of those companies would be a safeguard, would be a firewall, and take up the mantle. But one of the questions that I think needs to be raised is that something that the public at large wants to rely on, and is it something that the law ought to conform, or are we waiting for those kind of fights to happen at the level of the company as gatekeeper? And related to that is sort of what are the rights in the company itself? Increasingly, larger corporations like Google will have access to all manner of data, and there's widespread disagreement about what are they entitled to do with it. What expectations of privacy do people have vis-a-vis the company itself, notwithstanding what could be turned over to the government ultimately?
But those corporations have the financial resources to buy enough lawyers to fight that endlessly. I mean, they just keep sending you paperwork and paperwork forever, versus a smaller corporation does not have those resources.
That's certainly true. I think there's a lot of companies where they're increasingly using it as a marketing pitch that they fight back against the government. We've certainly seen that with Apple, we've seen that with Google, we're increasingly seeing that with Microsoft, where they're making public disclosures of how many disclosures they've been compelled to provide to the government in order to say this isn't as big as you might think, but also we're fighting it as aggressively as we can. One thing that's worth remembering is that in a lot of these cases, these are court orders for the information. And so in the event that you're getting a court order for information, you have much less opportunity to fight that. I mean, they appeal as high as they can, but in lots of these cases, it's settled law that in the event that a judge says, we need access to this, there's probable cause, we've got a warrant, or there's no warrant that's needed, but you've got your reasonable articulable suspicion, then there's nothing to appeal. The law is settled, and their very expensive lawyers are going to say, hand over the data rather than fighting it.
All right, so this next question will go to both of you, and then after that, we'll just open it up to more of a free-flowing conversation with y'all, okay, for the rest of the time. So this question is, in a perfect world, how would you balance privacy concerns from consumers and security concerns from law enforcement and intelligence agencies? And then I'm going to add another part that wasn't written here, the intellect and also the intellectual property interests of the manufacturers and service providers, okay? How would you balance these things? Do you have an idea about how you would proceed? Powers first and then...
Sure. So I think the line drawing problem is one that the courts have long wrestled with and continue to, and I'm not, don't yet have a sense of kind of where ought the line be. I do think that the courts are moving in the right direction, perhaps not quickly enough, but the third party doctrine, as it kind of grew up, we're seeing signs that it's being curtailed. We saw in a decision in the GPS tracking device case where the Supreme Court decided that attachment of the device to a car to watch it go around and track its movements was something that would require a warrant in advance. And in that case, Justice Sotomayor hinted that perhaps the third party doctrine would need another look. The majority didn't have to get there. They looked at that as a pure physical type of intrusion on on the suspect's vehicle. But I think what we're seeing is a move towards greater protection simply because of the recognition of the widespread reliance on third parties in order to be able to function today. And that means, you know, almost every person who uses a smartphone, which is nowadays almost every person, will have some of their data moved to the cloud, if not all of it. And it would be an awkward thing if the line drawing that people thought had to be made to have real privacy was that they would have to make sure that none of their data actually gets transmitted to the cloud or transmitted over a network of any kind. And so where it ends up is less clear to me, but I think that there's a need to move in the direction of greater protection of privacy, and that appears to be the direction the courts are moving.
Thank you.
Sure. So my view on this is that we sort of have to take a step back, right? The third party doctrine is about how the government can gain access to data that we have shared. I think when we look at where this ends up sort of quite long term, you sort of have to think, well, why are we sharing this information in its unencrypted form? And I think really the long-term solution to a lot of this is encryption, right? Because then you get to a point where these cloud service providers, they're very happy to take some encrypted data and give it back to the person that has the keys. And if the government says, well, can I have that encrypted data? They can give the encrypted data. It's meaningless, right? It just looks like random garbage. And then what you've got is you've got to a point where the people that have the keys are the people that can read the messages. And then we're back, I think, to a much more sort of natural position, which actually fits, I think, the third party doctrine much better, which is that if you don't want it to be, you know, leaked to the government, if you don't want it to be accessible without a warrant, don't share it. Encryption allows us to do this. It allows us to send a message from one person's phone to someone else's phone, such that it doesn't matter if there's people in the middle who, you know, are leaking the encrypted text, because they're encrypted. Only the person that you're intending to send this message to has access to it. And then the government has to go and ask them for the keys, but then you're back to, well, that person has Fourth Amendment rights. And I think that resolves a lot of these issues much neater than trying to come up with additional odd sort of judicial doctrines as to when you have X amount of data, you need a warrant, but when it's less than X, but also we have different qualities of data, you know, maybe it's location versus, I think you get into all sorts of, you know, tangled knots when you try and build up the doctrine rather than you just try and resolve it with encryption.
Yeah, I understand, but what do you do, what's your opinion on, you know, you have it encrypted and you think you have the only key, but the third party gives it to the authorities and they were able to decrypt it without your key. What's your opinion on that?
Well,
You need two keys, right?
so when I send a message to someone else via an encrypted app, all I need is I need them to have the key. I don't need anyone else to have the key. So I can send them a message, and anybody else in the world that intercepts the message can't decrypt it so long as they don't have the key that my friend has, right? So the government can then go to my friend and, you know, they can ask my friend, give me your key, right? But then in order for the government to do that, they're now asking my friend to open up his device, and my friend also has Fourth Amendment rights, so now the government needs a warrant against my friend rather than against me.
No, my question is more along the government decrypts it without the key.
Oh, so is it,
And that is possible.
maybe. So we
Not
have...
by a common person, but it is possible.
So the problem there is how do we make sure that we build encryption software that is secure even against the government?
I know, but what's your opinion? If the government is able to make a skeleton key, get your information without a warrant?
So I'm not convinced that they can build that type of key, but in the event that they could, then I think we are back into the same types of problems of surveillance at scale. Yeah.
I mean, the existing law would have tools to deal with that as well. I mean, the protection against entry into your locked home, car, other places is a Fourth Amendment protection and a requirement of a warrant. You would expect that the doctrine, even in the encryption scenario, would step in to protect against an intrusion that required essentially breaking the lock to get in.
Yeah, it's the same thing. I like that response. better. It's like, just like getting the locksmith to open up the door without a warrant. So if they get the NSA to go ahead and break into the code without a warrant, that would be the same.
But it's certainly it's a question. That's uncharted territory as far as I'm concerned, and so I think that we might have an expectation that the cases will come out one way, but we'll see where they come out when that issue gets decided.
Okay, thank you.
Great questions from you all morning. Who's going to help them out with other questions? Yeah? Okay, in the back there.
On the encryption front, sort of tying into the discussion earlier about corporations rolling it, is this something where persons are going to need to subvert the system and encrypt our own stuff, or can we expect corporations to provide encryption services like WhatsApp's done and stuff like that?
That's a great question. I suspect that it's going to be driven by companies, and it's going to be companies doing it for their own personal marketing reasons. And we've certainly seen that with things like WhatsApp. We've seen it with things like Signal Messenger. We've seen it with Apple, for instance, with iMessage. These are all now end-to-end encrypted communications, which means that it's very difficult for someone to intercept them and read these messages. They've done this because they've decided it's good corporate policy to do this. You can encrypt stuff yourself, but if you're anything like me, you don't have enough time. It's a lot of work. Are you really going to sit through 3 years of a computer science course in order to work out how you're going to do it? And bearing in mind that if you do it slightly wrong, then maybe it's not actually secure at all. So I do think that this is something that's going to have to be driven by the private sector and by industry rather than by individuals.
Can we expect other companies to spring up to help individuals? So instead of me having to encrypt my own stuff, other companies to spring up where they use technology to kind of jailbreak your existing technology or add on to your existing technology to help you encrypt stuff?
So you already sort of get that. So things like Signal Messenger is an app that runs on your phone, and it arrived before iMessage was end-to-end encrypted. So they're saying the fact that you've already bought this phone, it doesn't really matter. We can add encryption on top of it. But I think it's a really good question. I do think this is something that the private sector is increasingly doing. One of the difficulties is that they have all sorts of competing interests. So if you're someone like Google, you really like looking at people's mails because then you can get really good targeting adverts, right? And in the event that everybody's emails become encrypted, then you can't sell quite so good adverts, right? So they have these sort of competing interests. On the one hand, they want to say, we don't like the FBI, we're not going to give away all of this information. But on the other hand, we don't want to encrypt it so they can't, because if we do, then we can't sell quite so many good ads, which is this real problem of surveillance being sort of the industry of the internet.
Kathy?
Sorry, for the CL over there. I don't know if I missed it, but I know that there are federal laws that require corporations to respond to law enforcement or other kinds of requests for information. And I know that they have been, some corporations have been from time to time pushing back on that, but what is the legal framework around those federal requirements that if a law enforcement asks a company for your information, you have to give it?
Well, so I mean, one of the significant federal programs that Matt alluded to earlier is the Section 215 of the Patriot Act, which was sort of the legal basis for the surveillance program that was revealed through the Snowden release. And I think that in enacting that program and pushing forward, there was a heavy reliance on third-party doctrine as a way of justifying the collection of kind of a massive amount of metadata. And that's something that I think was able to occur in large extent without having to make a heavy reliance on the voluntary participation of companies. But that's sort of one of the most significant pieces.
Yeah, I mean, certainly with, I'm just about to see, certainly there's lots of statutes which require companies to retain records. Certainly in finance, in telecommunications, there's requirements that companies retain information for billing purposes. And that causes problems because then that means that that company can't say, well, for privacy reasons, because of this third-party doctrine, we're not going to collect this information so that it wouldn't be available to the government if they wanted it, because they're required by statute to keep it. So I do think there's some interesting interactions between how you resolve the fact that the company is required by the government to keep it, but also there's this third-party doctrine that means that the government doesn't need a warrant to then obtain it later. So the company is keeping it, but they don't want it, but the fact that they've kept it means that the government can get it. So it's all quite complicated.
Yeah.
In the instance that you just said, if the company, as a third party, encrypts the information on their ad report, then where does it fall under the law?
So this is, the question is whether or not it's encrypted on the user's device by the company's software.
Well, no, in their own databases. Once they collect all this data and they're storing it on their servers and they choose to encrypt it, then how does the law extend to them as a third party holder of that data?
So that's
Are
a,
they required to, once they encrypt it, does it then come under their privacy or is it?
So the question is whether they're able to decrypt it later. So in the event that they encrypt it such that they can't decrypt it, then they can't be compelled to give it over. It's impossible, right? But in the event that they encrypt it just temporarily, and they have some subsidiary out in Germany that's able to decrypt it for their German customers, then it really doesn't matter. Because the company is able to decrypt it, the government is able to compel them to obtain it and to take appropriate measures to decrypt it. And there's a case that happened recently called the Microsoft Ireland case, where Microsoft had a data center out in Ireland. I believe it was the FBI was very interested in the content of someone's a Microsoft account. That data physically resided over in Ireland, and Microsoft said, well, this isn't in the United States, you have no jurisdiction here, we shouldn't have to go and collect this data, this belongs out in Ireland. And the court said no. Because you're able to get it, you have to get it. So that's going to be the case, I suspect, even with encryption. If you can decrypt it, you're going to be compelled to decrypt it eventually.
I'm interested in sort of the encryption solution. One of my reactions is that some of the limitations it would face would be a very robust third-party doctrine might say, so long as a third party is involved in the encryption and has some access to the key, even if it's the encryptor, that a third-party doctrine might say, well, you've lost your expectation of privacy. So I think there needs to be some doctrinal response to these issues that goes beyond the technological. And for the same reason, cell site location information is the kind of thing that is gathered about people when they use devices that I don't think any person has a real encryption defense to, because no one is going to have control over how the data about their movements in the world are treated by a third party. It's not in their hands.
All right, so to clarify, a third party can be compelled to decrypt if they have the ability to
Yes.
decrypt.
Yes.
New news to me. That's not good news, is it?
So I guess actually, and this is sort of slowing that question, if you have a key system that they relinquish the keys, whether and they had no access to that key, then they would also release the liability of having to increase that into decrypting, right?
Yes, and you see this in things like the financial sector, where they say holding some of this data actually comes with all sorts of liabilities. I actually saw this at Microsoft, a couple of cases where they had information they were storing on behalf of users, and they took a look at it and they said, this is a horrifying database. We don't want to have this, right? Because in the event that something goes wrong and it gets breached, lawyers will be all over this, it will be a disaster. So what they wanted to do is they wanted to build it so that it was encrypted specifically for liability reasons, so that they could say, we're storing encrypted stuff that we can't see, nobody can compel us to see, nobody can take it from our servers. If someone hacks in, they don't have any access. And I think encryption is a good way of solving this, not just from sort of third-party, doctrine perspectives, but also from liability perspectives. If you don't have the data, then you can't lose it.
So if they can't decrypt it, who can? I'm a little confused about that.
Oh, so you have the company, but then you also have the users. So if the user has the device key,
I see.
then the company can get hacked as badly as it
Right,
matters,
right.
but the encryption key belongs to the user.
I see. All right. Do you get the distinction there?
Absolutely, that is exactly.
Okay, great. And
In
Sam,
encryption, there's multiple keys. There's a public key and there's a private key.
Yeah, you can design
There's a
systems
master
with
key that
loads of
these
different
two
keys.
are made from.
Yes,
I mean, there's multiple keys in the process of encrypting and decrypting
correct, yes.
technology.
Samuel, have we run out of time?
I think we got 2 or 3 minutes.
Alex?
Yeah, I have a quick question. So I'm a little bit ignorant about how HIPAA laws work. So how might HIPAA interact with third-party doctrine? So for example, in a telemedicine situation where you're communicating with your doctor over some device that, normally falls under the third-party doctrine, is there some sort of protection there?
So my immediate reaction would be that HIPAA is meant to govern the disclosure of protected health information by the healthcare provider, and so I think that third-party doctrine is less likely to be at issue because that's really a response to the Fourth Amendment question. Is there a capability of making a search or seizure without having to go through the process of getting a warrant? Once you're in the Fourth Amendment world, now you're thinking about questions like physician-patient privilege and other issues that I think will take you sort of further afield of what third-party doctrine would have anything to do with. But it's an interesting question. What happens when other entities besides the physician are kind of involved in the situation, because more and more you see people looking for ways to take advantage of technology, and you can picture additional intermediaries that would interfere with both the physician-patient privilege as well as other expectations of privacy you might otherwise have.
Yeah, that sounds right to me. That the third-party doctrine is governing sort of the baseline Fourth Amendment question, and then you have HIPAA on top of that. So it's whether or not HIPAA, I don't know enough about HIPAA, but it's whether or not HIPAA has an explicit warrant requirement. I suspect it probably doesn't, because I don't think it's for that purpose.
All right. Well, thank you, gentlemen, for participating in this discussion and helping the Cyborg project. And thank you all for waking up this morning. Now you know a little bit about cyborgs, cyborg rights and why we need them, and how they intersect with this dangerous third-party doctrine. And you have enough knowledge to be dangerous. Thank you. Okay. Bye.